Is this just the voir dire?
It's the entire first day.
First day, all right, thank you.
All right, Your Honor, on behalf of Ms. Benefield, and pursuant to our motion to interview the jurors, which, a lot of which was incorporated in our motion for new trial, first thing I want to address is the juror misconduct. The court has pretty much framed the parameters and that the prosecutorial misconduct allegations are for another day, if at all. So for today, we're going to discuss what I've characterized as identifiable and unidentifiable juror misconduct. I think as it relates to identifiable juror misconduct, that term is being used and focused exclusively on juror number 15, that was Sarah Walcott. And I want to remind the court as I go through my argument that at the conclusion of jury selection, the defense still retained one peremptory challenge. Now, the most compelling evidence of identifiable juror misconduct as it relates to Ms. Walcott is the following. First thing I'd like to do, Your Honor, is supplement to our Exhibit E on our motion for new trial, or Exhibit B on a motion to interview jurors. I want to supplement it with a copy of Ms. Walcott's questionnaire. If I could have the clerk mark it. Does the court want a separate copy?
Yes, please.
Do you have a separate one?
Yes, I have copies
That's
for
okay.
everyone.
And clarify again, you said this is an additional page to Exhibit B of the defendant's motion to interview jurors.
Yes, B for the motion to interview jurors and the E for the motion for new trial. And may I present a copy to the clerk for marking?
Yes.
So, the questionnaire, Your Honor, contains a very obvious admonition that says, under penalties of perjury, I declare that I have read the foregoing jury questionnaire and swear or affirm that the facts stated in it are true. Now, one of those questions, as I've highlighted for the court and for the record, is, quote, have you or a member of your immediate family been, unquote, victim of a crime? Ms. Walcott put an N in that block indicating no. We filed in our motion for new trial under Exhibit E and in our motion to interview jurors, Judge White, under Exhibit D, a domestic violence injunction petition filed by Sarah Walcott in case number 2016 DR 001301AX. The facts also include are that her then boyfriend, Albert Ballinger, was arrested on February 20th, 2016 for allegedly grabbing her hair by the back of her head and slapping her across the face 5 times. The deputies observed redness on the left side of Miss Walcott's face. Mr. Ballinger was arrested, and Miss Walcott filed a petition declaring herself to be a victim of that offense. That is in absolute and direct contradiction to the form that she signed under oath. Additionally, Your Honor, during the voir dire portion of the trial, the following questions were asked There's not a whole lot of relevant ones, but to set the stage for the court before I read the exact questions, Ms. O'Donnell had asked about child custody matters, and I had asked about experience in the domestic violence courts. Here are the specific questions that were asked, and the pages and lines where they appear. On page 233, Judge White, line 9, Ms. O'Donnell asks, have any of you here ever had any dispute with your significant other about your child or the custody of your child? Additionally, Ms. O'Donnell asks on page 234, line 23, has anyone here ever had like a heated custody battle with anyone? She then acknowledges another juror, 26, who raised their hand, and she goes throughout her voir dire very meticulously back and forth each side of the courtroom, left and right. As the court knows, the jurors were numbered to a certain amount on the left side and then the remainder on the right side. Additionally, on page 236, line 17, Ms. O'Donnell is heard to say, and how about over here?
I'm sorry, you said 276?
236. Your Honor.
236.
Line 17.
Thank you.
If I'm going too fast, Judge, let me know, I'm sorry.
I'm just writing as fast as I can. Go ahead, sir.
On line 17, Ms. O'Donnell asks, and how about over here, indicating to the right side of the courtroom where Ms. Walcott is seated. There were several other people that raised their hand. Anyone that's had a contentious battle besides number 26 in the back over here? How about over here on this side, number 51? On the next page, 237, Judge White, line 15, Ms. O'Donnell asks once again, and who else over here on this side? And she calls out juror number 62. On page 38, and this is still over child custody matters, page 238 on line 14, Ms. O'Donnell asks, okay, someone else raised their paddle. 38, and you had a custody dispute with your children? Prospective juror, 38, yes. And finally, on page 239, Ms. O'Donnell goes back to the other side once again, and on line 8, she asks, anyone else on this side of the room? Okay, no one else. Now, she finishes her voir dire, and the court calls on me. And on page 283, Your Honor, line 19.
Yes, sir.
I asked the following question of the veneer. Has anybody in the prospective veneer been involved in domestic violence courts? There's a show of paddles. I follow that up by asking on page 284, line 8, how many of you know or have experienced an abusive male? And I might add that the court reporter, of course, is diligently noting the paddle numbers of the jurors that respond affirmatively, and the court will note juror 15 is not among them at any point. And the court report even goes so far as to say on line 22 of the same page, 284, court reporter, wait a second, I need your paddles, don't just yell out. Now let's look at what the evidence is that we produced for the court in light of that those voir dire inquiries? Well, first, we provided Your Honor with Exhibit G to the motion in new trial, or alternatively, Judge White, Exhibit E for the motion to interview jurors. We provided the court with a domestic violence injunction where Sarah Walcott was the respondent, the person that it was filed against. It was by her ex-husband. The case number is 2003 DR 4890. This was a domestic violence injunction filed and sought by her ex-husband, Charles Walcott, on behalf of their minor son, Hayden Walcott. The ex-husband sought custody of the minor son. The petition was ultimately dismissed, but for our purposes, that's completely irrelevant, as it was filed against Ms. Walcott. In case that's not enough, Your Honor, as Exhibit H to our motion to new trial, which was Exhibit F to our motion to interview jurors, we attached another domestic violence petition filed against Sarah Walcott, case number 2004 DR 002205. It was an injunction once again sought by her ex-husband, Charles Walcott, once again on behalf of their minor child, Hayden. In this instance, the court issued a temporary injunction to Mr. Walcott, and Mr. Walcott sought and was granted temporary custody of the minor child, Hayden Walcott. Mr. Walcott's accusations in that petition alleged child abuse against Sarah Walcott, and specifically stated that Sarah Walcott, quote, picked up the minor, Hayden, by the arms and slammed him against the wall. The significance of that, of course, Judge White, is that Ashley Benefield made child abuse allegations against Douglas Benefield. And I assure you, especially given the voir dire that the court conducted, we took several hours that the court patiently went through all prospective jurors that were subject to cause challenges. I have a very high degree of confidence, had this information been revealed, Ms. Walcott would have gone out on a cause challenge, and I don't think that the state would have objected to it. However, that too is really irrelevant because the defense had a peremptory challenge that remained, and I can tell you unequivocally we would have excused Ms. Walcott had it been disclosed. Additionally, Your Honor, Hayden Walcott, again, this goes to the voir dire question about have any of you been involved in the domestic violence courts, and the court may recall that the petition, the questionnaire rather, that Ms. Walcott executed says her or her immediate family, which would include her child, Hayden Walcott. We attached as Exhibit F to our motion for new trial, which is also Exhibit C, as in cat, to our motion to interview jurors, an aggravated battery charge against a pregnant victim, case number 2014 CF 3121, against Hayden Walcott. She was the victim, Mr. Hayden Walcott's live-in girlfriend. He appeared on the scene heavily intoxicated, and Sarah Walcott posted the cash bond for him to be released. Once again, despite the question about domestic violence, no disclosure. And finally, Your Honor, again, as it relates to the voir dire, in a bar fight charged with felony battery on June 1st, 2024. This would have been right prior to us selecting the jury and the trial commencing. In Manatee County Sheriff's Office, arrest number 2024-012314, which I would also at this time ask that the clerk mark as a supplement to our exhibit F to our motion for new trial, and mark it as F2.
Any objection? State?
Relevance, first of all, I don't know what it is, first time I've seen it.
It's the arrest affidavit of Hayden Walcott for what I just stated.
I don't know how that's relevant.
All right, so there's an objection is relevance. Any other objections?
No.
Go ahead. Overruled. So
Have the clerk mark a copy to
Mark that
supplement
as
to exhibit F of our motion for the trial.
F2. F2. All right, yes, sir?
This is a bar fight on June 1st, 24, where Mr. Hayden Walcott is observed on video, according to the deputy, punching the victim in the face with, quote, significant force, once again, not disclosed in voir dire of the questioning of Ms. Walcott about abusive males or domestic violence. The second part of our presentation, Judge White, goes to the unidentifiable juror misconduct. And that is where we have a witness standing by to testify. I'll go through it if the court likes, and then I would like to call the witness, but of course that'll be up to Your Honor. So, this is what happened. If the court recalls, on the evening of the verdict, the first thing that occurred was a question from the jurors about whether or not Dr. Quintel's conclusions about Doug Benefield being A, super controlling, B, a real alpha male, and 3, having an issue with intimidation, was Dr. Quintel's conclusion or based upon information that Ashley provided to him. At the time they asked the question, I took the position, believing it to be pretty simple, that a readback of Dr. Quintel's testimony would quickly put an end to that consideration, because my question to him was, did you, Dr. Quintel, as an expert trauma specialist, reach any conclusions as it related to Douglas Benefield? There was a dispute with the court about whether or not the jury knew that they could ask for a readback, but what then followed, Your Honor, was a really puzzling and very alarming recitation of events on a public website by law and crime networks called Verdict Watch. We were able to capture it before it was taken down, and it was taken down pretty soon after it was posted. But there was an individual by the name of that hoodie guy. And what was so alarming about this was that everything that the hoodie guy reported came to pass exactly as he reported it, but a couple of minutes later by the jury. So, for example, at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, the hoodie guy posted, a comment stating verdict incoming. That's Exhibit A1 to our motion for new trial.
All right, I'm looking directly at that. I'm looking at motion to interview jurors. I'm looking at defense exhibit A1, the first page of that.
On the motion for new trial, I'm going back and forth between the motion for new trial and the request to interview jurors.
All right, then is the exhibit in the motion for new trial different than the motion to interview jurors? Because I'm looking at A1 from the motion to interview jurors. It says exactly what you just said.
I believe we repeated it. Let me just do a real quick check here. Yes. These are the actual screenshots in the motion to interview jurors that we provided for the court. The summation that I'm giving the court is coming from page 23 of our motion for new trial.
Okay, so my question is, both on page 23 of 26 of the motion for new trial, and today during your oral argument, you've referenced verdict incoming as being at 10:20 PM.
Yes.
The, what I've been provided doesn't have a timestamp. How are you able to make that assertion?
I believe we made that assertion by virtue of preserving and noting, as it was taking place, what was happening. That's one of the reasons why we have the witness standing by, Your Honor.
Okay,
All right, so the second thing that happens, that at 10:25 PM, moments before the jury comes in, that hoodie guy posted a comment stating, quote, "Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter." Now, the court may recall that following that first question and the dispute about the readback, the court told them, rely on your recollection, and sent them back out. They returned shortly thereafter and said that they were hung. This was what was posted as a result. The next thing that's posted at 10:27 PM, according to that hoodie guy, is a comment stating, "My sister snuck a flip phone in." That's Exhibit A3. At 10:28, Your Honor, that hoodie guy posted a comment stating, "I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter." Exhibit A4. At 10:28, that hoodie guy posted a comment stating, "My sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter." And at 10:30 PM, the jury comes in and announces they have a verdict of manslaughter. And that was a mere 2 minutes after the hoodie guy posted what he did. I will defer to Mr. Pennell and any discussion the court wishes to have with him about juror interviews and what the rule says. But I would remind the court that the standard in the rule is not very high. It requires reasonable basis to believe that the verdict may be subject to attack. And if so, if that is shown, the court does not have discretion according to the rule. The rule says the court shall order an interview. And of course, that's the whole purpose of the interview. It would be to discuss whether or not something like this in fact took place. I further tell the court that as it relates to Sarah Walcott's falsification of the questionnaire and refusal to disclose on voir dire the independent evidence that we've discussed here today, I do not see respectfully any way that the court's going to be able to get around that. That is misconduct proven beyond any doubt. And you can try to parse the question, have you been involved in the domestic violence courts any way you like, but I don't think you'll be able to do it in such a manner as to eliminate the fact that you had not one, but two domestic violence petitions filed against you, which you did not disclose, and that your husband sought custody of your minor child, and you did not disclose that either in response to the state attorney's question. With the court's permission, I'd like to call Ashley Boyer now to testify to the...
Judge, and I'm going to object. I have not been notified of any witness. They have not listed any witness. I have no idea who this witness is. Their discovery obligations are to tell me who their witnesses are, so I have the opportunity to know who they are before they call them. So I don't even know who this person is.
This is a person who approached us after the verdict or immediately before the verdict to show us pictures of what was being posted on the Law and Crime Network's Verdict Watch, and told us that she thought initially that it was just some troll that was looking to inject themselves into the proceedings, but when she noticed the timing and the subsequent verification, if you will, by the jury's actions, she brought it to our attention because she was concerned. She is independent. She's not affiliated with the defense in any way.
Has she been disclosed?
We haven't had a discovery request for this hearing, Your Honor.
So, the state has to ask for that information?
No, we haven't. We never received a
So,
request for it.
has there been a disclosure pursuant to the rules? You have to list, well, you know what?
Yeah.
All right, so no.
In addition, we did not know if the court was going to actually take testimony here today based
So
on...
don't disclose her unless I decide to hear her and then disclose her.
So,
Okay? And you want her to present testimony remotely?
yes, she's
Have you filed a motion under
Yeah.
Rule 3.116?
about 9 months pregnant, Your Honor. No.
Okay, all right, denied. I mean, the rules are clear. Now, I'm confused. Was that the opening, and then you're gonna do the closing?
No.
I was just gonna
That's-
discuss, I was gonna discuss the rule and the case law.
All right,
That's our motion.
Just,
all right. Do you have anything else you want to say,
Yeah,
and then
I
I'm gonna
have-
go to the state?
Yeah, I have one other request for the court. We're under the impression, Your Honor, that there is court security footage, video that's maintained. If there is, we'd like to make a request that it be preserved because we think it may show Ms. Walcott and whether or not she responded in any capacity. Trying to give the court reporter the benefit of the doubt that maybe she missed Ms. Walcott holding up a paddle to any of these things. So to the extent there is such footage, in the interest of justice, we would like, Your Honor, to take steps to preserve it. Mr. Pinnell will address with the court any questions of law that the court has.
All right, I am not the custodian of the information that you're referencing.
I understand, but I think if the court asks that it be preserved, I have a high degree of confidence that it will be. Is that acceptable to Your Honor?
Sir, I'm not the custodian. If you want to file a motion, I guess we can have the parties here and we can be heard on it, but I'm not the custodian of those records. State?
first, Judge, I would object to the lawyers tag teaming with their arguments. This is, one lawyer can do these arguments, whether it's factual or legal. That being said, I first want to address the paddle issue. The representation that Mr. Taylor has made about what happened in jury selection with those paddles is completely and 100% inaccurate. When those questions are asked, paddles are raised. The court reporter does not write down the number of every paddle that was raised. Not once have I ever seen in a transcript that the court reporter tries to write down 30 different paddle numbers as to who raised their paddles. I cited in my motion 2 different places where I asked very specific questions, and I started asking questions in response to that. I can represent to the court that I almost never go to every single person that raises their paddle. That is a habit of mine. I don't go to every person that raises their paddle. So to make the assumption that someone did not raise their paddle based on the fact that I did not speak to them, I think is completely improper. And I also believe that the defense asking the question, has anyone had any contact with domestic violence courts? He says in his response, 2, which I'm assuming means he saw 2 people raise their paddles. Nowhere in that transcript does anyone say what numbers raised their paddles. It is quite possible that Ms. Walcott did raise her paddle, and we are sitting here maligning her, acting like she withheld this information inappropriately, which I find highly objectionable. And the rules for this sort of thing, interviewing jurors, yes, jurors can be interviewed, but what Mr. Taylor did not mention is how strict the standard is in order to get to the point where you interview a juror because of public policy reasons. Because how are we ever going to get jurors to come in here if they know that after the fact someone is going to dig into every aspect of their life and call them liars when they didn't lie and distort the record to meet their own needs? There has to be a line drawn. And I would like to bring the court's attention to, it's in my motion, but I'll state it just briefly. The case of Baptist Hospital, which is cited in my motion, and also the case of State versus Hamilton, which I believe defense also just provided. It says, when you're talking about juror non-disclosure, however, in the light of strong public policy considerations, Florida law only allows juror interviews in limited circumstances where the moving party has made sworn allegations that, if true, would require the court to order a new trial, because the alleged error was so fundamental and so prejudicial as to vitiate the entire proceeding. And additionally, in Hamilton, it says, when a defense or the proponent of this fails to allege facts establishing a prima facie argument for prejudice, they do not get to interview jurors. And it is the state's argument that the defense has not provided prima facie evidence of this. The defense is saying lots and lots of terms and commingling. There's victim of a crime, charged with a crime, custody battle, injunction, and I think it's all getting blurred together. So if you go by exactly what the defense is saying that Juror 15 did, the first thing is that she allegedly was intentionally not disclosing that she was a victim of domestic violence. And using the questionnaire where it says, have you or a member of your immediate family been the victim of a crime, yes or no? And it is checked no. There is no evidence of any intentional deception. There are very, very different definitions of the word victim. Is it a victim in an injunction? Is it a victim in a crime where someone is arrested? How about if you're a victim and someone is not arrested? How about if you're a victim and the police come out and they don't even file charges? So that's why it is incumbent upon the attorneys to ask these questions, is to clarify, because not every person answers these questions appropriately because they don't understand what exactly legally is meant by these. Additionally, how many times have we gotten questionnaires that have absolutely nothing checked on them? Would that mean that they're lying as well? That's why I believe you cannot rely solely on a questionnaire. You have to delve into it. And the record itself, the transcript that you have, shows that the defense did not delve into this appropriately. Because even when he saw paddles raised, he did not go to those people that raised their paddles. So if he had exercised his own due diligence, perhaps could have found out this information and found out why Juror 15 maybe misunderstood or mischecked this box. But to insinuate that this person was lying on purpose is quite frankly offensive. And I do not believe that we can attribute that to her just based on a written questionnaire, when the attorneys did not follow up appropriately one way or another. Also, the fact that she was a victim of domestic violence, according to the standard for non-disclosure, the defense has to show that it was material to the jury service and that it was prejudicial. So how is the fact that this juror may have been the victim of a domestic violence situation prejudicial to a person who's claiming they were the victim of a domestic violence situation? So quite frankly, it's to the contrary. I would think that a juror that was misrepresenting or that was a victim of domestic violence would be sympathetic to a defendant who said, I was the victim of domestic violence. So in that regard, the defense cannot show any prima facie case or showing of prejudice. Then the defense in the written motion talks about the son was the defendant in a domestic, and then also now somehow the son's a defendant in a bar fight. I'm a bit flabbergasted as to how this even is relevant that he was in a bar fight. I don't recall anyone being asked if anyone had ever been in a bar fight, but the questionnaire says, have you or a member of your immediate family been charged with a crime? And she did answer yes. So I'm not sure where the son's charges fit into this, unless the defense attorney is trying to say that, have you been involved in domestic violence courts somehow encompasses the son being charged. But if it wasn't Juror 15's charge, then why would she answer that question in the affirmative? So I think it's blurring many, many lines together. But when you break it all down, she made no improper representation about her son. She never said anything improper, and none of the questions that were asked by the attorneys in the questioning pertain to anything like this. So the defense cannot show prejudice in that regard either. Then, Judge, there's the fact that she had these domestic violence injunctions. The defense in their motion says child custody / domestic violence / abuse matters. But there's no evidence in the transcript. If you get the opportunity to read the transcript, the state found several places, and the defense talked about them. The state did ask, has anybody had a dispute about child custody? Never once did I state who raised their paddle, and I do not represent that I talked to everyone that raised their paddle. Again, I said, has anyone had a heated custody battle? Same thing. People raised their paddles. I spoke to a few of them, make no representation that I hit them all. Then the defense said, has anybody ever been involved in domestic violence courts? And that's when the two people raised their paddles, and then he moved on to a different question. So at least where it comes to that, I don't believe there was any misrepresentation at all, or that the defense can show that there was any misrepresentation. And the defense didn't follow up on any of those questions when he asked, has anybody been involved in domestic violence courts? If you read the transcript, he just moved on to another question. He did not follow up with those two people that raised their paddles. So as it applies to juror number 15, the state's argument is that the defense has not made a prima facie case of prejudice, or even in most of these, he hasn't even made a prima facie case that the information was withheld or that the juror was untruthful. Also, Judge, this trial lasted 7 business days. So that's, 9 days with the weekend. This jury was picked on a Monday. This information was not written in a motion until well after the verdict. This is information that could have been gleaned from the defense, because clearly they got it from somewhere. They could have gleaned this information while the trial was still going on, while we still had alternate jurors here, while we could have asked Juror 15 these questions, but the defense waited until after the verdict did not go in their favor to then put forth all of this information where we are in the position that we're in now. And I believe the case law is very clear that that is not what this was meant for. It was not meant for you to wait to the point where it's irreparable to bring it up. That it should be brought up as soon as someone has done their due diligence enough to find the information on their own. If the defense was going to research every juror, they could have done it during the 9 days that this case was pending while these jurors were still seated. As to the, what I call the second issue, the potential phone in the jury room, first of all, the comments that are attached to this do not have times on them. It says how long the verdict
That's incorrect.
clock, it may be incorrect, but some of the ones I'm looking at do not have times on them. It just says verdict clock 6, like for instance, I'm looking at Exhibit A-5, and it says verdict clock 6:18.
If the court looks at the bottom right-hand corner, next to the white space bar on the bottom, it's a clock. And that's where the time is come from.
Okay, I can't read that. So if it's on there, is it here? The little, in the red?
Yeah, it's in there, space. It's a ticking clock.
Okay, I can't see it.
But the thing is, you can play these messages at any time.
Anyway, Judge, I do believe that there is some discrepancy about exactly when these comments were coming in, but it is also the state's argument that this is an anonymous source. And we know from the law and how we deal with anonymous sources, they are given the very least amount of credibility. They are not to be believed solely on their own. So we should not give this anonymous source any more deference than we would give any other anonymous source in the legal system. One of the things that is internally inconsistent is that this person is apparently saying his sister is on the jury. And his sister has a flip phone, his sister's giving information. But the comment that says, this is what she just texted me, and then he gives like a colon, per sources, 5-1 guilty. Why would a juror say per sources? A juror would just say, we're saying 5-1. They would not say per sources. That indicates to me that whoever this hoodie person is, if they are getting the information, is getting it from someone other than a juror, not someone that's on the jury, because why would someone on the jury say it like that? Additionally, the court gave instructions to the jury all throughout the trial, all throughout every break that we ever took. You inquired to them after they came back from every break, have you gotten any information from anyone? Have you heard about the case? You know, whatever those specific questions were. And the jury indicated negative each time. The jury never any time during when they were deliberating or any time thereafter said anything to the court that they had information that someone was acting inappropriately or someone had a phone or something like that. They never said anything to you, even though for days and days and days they knew you were asking this question every single time. Also, Judge, even if you do take that this person somehow had a flip phone in the jury room, there is no indication that there's anything other than outgoing texts. Even if there is, which I don't think there was, but even if there is, these are outgoing messages. There is absolutely no evidence or even indication that there was anything incoming that would have tainted this jury. And I would like to read from, it's my motion, and it's quoting the Mailer case, M-A-L-E-R, that I cited in my motion. In order to constitute juror misconduct sufficient to allow post-trial jury inquiry, the objective act must have been committed by a juror which compromised the integrity of the fact-finding process. And then there are examples listed in this case. And some of the examples are, a juror was approached by a party, his agent or attorneys, witnesses or others conversed about the facts and merits of the case in the presence of the jurors. Number 3, the verdict was determined by aggregation and average or by lot, game, or chance, or was other improper manner. Number 4, a jury went to the scene and reported its observations to the rest of the jurors. Number 5, a juror had a personal knowledge of the case and conveyed this knowledge to the jury. Those types of things are listed in the case as being objective acts which compromise the integrity of the verdict. Some anonymous post that we have absolutely no evidence of where it came from, it is more likely than not that this person got the information from some of the press people running around, or maybe court personnel that might have known something was going to happen. There's no indication that this was from inside the jury room. There's no indication that it was anything other than somebody posting on social media trying to get attention. And for us to inconvenience these 6 jurors in this manner, in this contentious case, in this way, it's quite frankly not appropriate. And this defense has not produced the minimum prima facie evidence in order to get an interview of the jurors. So we would ask you to deny the request.
Thank you.
Can I make a brief argument?
I don't mind if one of you wants to take the first part of a closing or argument and the other takes the second part, but I don't disagree. It's one or the other. Mr. Taylor, if you want to stand up and you want to address the court for your rebuttal, I'm happy to hear it. If it's going to be Mr., I'm sorry, again, I put it
Pinnell,
away.
it's okay.
Pinnell.
Pinnell.
I'll defer to Mr. Pinnell, Your Honor.
May I approach the case law?
Yes, or hand it to the deputy?
Sure. Your Honor, I don't want to waste time on platitudes, but everybody in this courtroom knows that the jury system is based on their jurors being honest and forthcoming and giving correct answers, whether they're intentionally correct or incorrect. Doesn't really matter whether they're intentional or not, it just matters whether they're accurate. The state alleges that the motion should have been filed sooner. The rule says it has to be filed within 10 days of the verdict. It's clearly filed within 10 days of the verdict. The idea that Mr. Taylor was supposed to research the jurors while he was busy defending his client, I don't think is a fair assertion. He had plenty to do representing his client in a murder case. The state raises a lot of good questions about what we don't know. And what I would suggest is they've actually proved the point. We don't know a lot of information, and the reason, and that gives us a reason to interview the jurors. As Mr. Taylor said, the rule does not, although juror interviews are disfavored, the rule has a pretty low bar. It says a party who has reason to believe that the verdict may subject to legal challenge. And it says the motion shall state the name of any juror to be interviewed and the reasons the party has to believe the verdict may be the subject of challenge. And upon a finding that the verdict, quote, may be subject to challenge, not definitely, not 80%, may be subject to challenge, a juror interview shall be ordered. Respectfully to the court, as an officer of the court, I don't think this is a close call. I think there's significant evidence that Juror 15 either intentionally or unintentionally did not provide a full disclosure to the questionnaire and to the voir dire questions. What we haven't heard from the state is any allegation that they recall or saw Juror 15 raise her paddle and Mr. Taylor not question her. I'm assuming as officers of the court, had they seen that, they would have told you that today. Mr. Taylor's sworn motion says, based on his recall and his notes, that he does not believe Juror 15 ever raised her paddle, and that's the evidence that she didn't give a full disclosure. And we're here today to determine whether we get an interview, not whether we get a new trial, and so I do think the state is blending those two together as well. We're not at the point where the court is in a position to decide whether we're entitled to a new trial. We're at the point where the court is in a position to determine whether we're entitled to a juror interview, and I think, again, the evidence that's been presented easily meets that standard. I point the court to the Uther case, and it's Huether versus Barani. This is a 50 CA case from August 20th of this year. And on page 2, if you're using the bottom right-hand corner, there's a statement that initially we note that Florida law has long recognized that post-verdict juror interviews are strongly disfavored and should be rare. But then they say on page 3,
You're talking printed page 3,
correct.
okay?
But then in the second full paragraph in the left column on page 3, it says further, even though Florida law rightly makes post-verdict juror interviews rare, where adequate proof suggests that a juror has acted improperly and contrary to lawful instructions of the trial court, an interview of the offending juror is appropriate. Then in the indented quote on page 3 in the right-hand column, it says, it is the duty of the juror to make full and truthful answers to such questions as are asked him. A juror who falsely misrepresents his interest or situation or conceals a material fact relevant to the controversy is guilty of misconduct, and such misconduct is prejudicial to the party, for it impairs his right to challenge. Lawyers representing clients in litigation are entitled to ask and retrieve truthful and complete responses to the relevant questions which they pose to prospective jurors. They are entitled to evaluate this information in determining whether to seek to excuse prospective jurors on peremptory challenge or for cause. So that's what happened in this case. At least preliminarily, the defense has made a showing that Juror 15 did not disclose her involvement in domestic violence courts. She was involved both as a petitioner and a respondent. She made an allegation that she was the victim of domestic violence. I understand the state's argument that there's different definitions of victim, and I think that's why we get to ask her questions about it in a juror interview. But this case, this Huether case, is a case where the judge denied or granted juror interviews based on a failure to disclose information, and the opposing party sought to file a cert petition to preclude those interviews, and the 50 CA said the interviews were appropriate. And in explaining their decision at the bottom of page 3, it says, it appears quite possible that JL concealed material information from the court and counsel. So they just say it was possible. Based on the allegations of the party in the case, it was possible, and they found that was enough to justify a jury interview. And then they cite favorably in footnote 6, this is on page 4, before a party to a lawsuit should be denied the benefit of a favorable verdict and forced to endure the time and expense based of a new trial based on juror misconduct, the trial court should at a minimum interview the juror with the attorneys present and then make a finding of whether the contact was intentional and whether any party was prejudiced. So they're saying that before we move on to an appeal or a new trial, we need to be careful and interview the juror when there's prima facie evidence of the failure to disclose relevant information. Certainly based on the allegations and the facts of this case, whether an individual was the victim of a crime, the victim of domestic violence, the perpetrator of domestic violence, would be relevant to whether the defense would seek to excuse her for cause or based on a peremptory. Mr. Taylor has stated under oath and today that had he been provided this information, he would have excused Juror 15. The Hillsborough case, 4th DCA, 2013, under Head Note 3, it says a juror's non-disclosure of information need not be intentional to constitute concealment in context of a motion for new trial premised on that disclosure. So the state spent a while talking about maybe the juror didn't understand. And that's fine, and maybe if the juror didn't understand. But if the information's incorrect, it's incorrect, and it's a basis for new trial. And And that's another case where the DCA said that there was reasonable grounds existed for a juror interview. It's our position with regard to Juror 15, the wealth of evidence that the defense has presented easily meets the burden of proof under 3.575, and that the court should grant an interview where she is asked to confirm whether she was the petitioner in those particular petitions, whether she was the respondent in those particular cases, and whether she was a victim of a crime. And that would then conclusively establish for the court whether the information she gave was complete and accurate.
So those are the questions you believe would be asked at the hearing. Were you the petitioner? Have you ever been the petitioner of a domestic violence injunction? Have you ever been the respondent of a domestic violence injunction? Have you ever been the victim of a crime, a domestic violence crime? Is that it?
Those are the first three I could think of. I think there could be a couple more, but that would be the general context of the question.
That's what I guess I'm asking is, how deep does this go? Is it then digging down into the specifics, and here's a police report, and it says that this happened and this happened?
No, I agree with you. I don't think that would be necessary. I think those first three questions, you know, without thinking it through, I could probably think of one or two more questions, but I think the court's concern is consistent with the case law that it's not supposed to go that deep. All we need to do is establish that it was not accurate at the time the statement was given, or when she failed to raise her paddle, or when she answered the questionnaire. So I agree with the court that it wouldn't have to go into more details. It would be limited to that general subject matter, and then we'd be able to make argument whether that was prejudicial.
All right, thank you, sir.
As it relates to the cell phone, it's clearly against the rules for a juror to bring a cell phone into deliberations. We don't know today whether that happened for sure, but I suggest that we have strong circumstantial evidence, and I know the state stands up all the time and tells you that strong circumstantial evidence is as good as direct evidence, that there was a cell phone in the jury room, or at least a reasonable basis to question that under the rule. The YouTube user, that hoodie guy, said there's a jury, my sister snuck a phone into the room. So the idea that there's no evidence is just not true. And then the timing lines up this too accurately for it to be a coincidence. The state is speculating that they may have heard it from a reporter, or they may have heard it from someone else. Maybe that's true, but that's why we get to ask the jurors the questions about it. And I'd cite two cases: the Needleman case, where a juror did outside research and then discussed it in the jury room regarding the definition of bribery and the penalty for bribery. And then the Tapanese case, TAPNES 4th DCA, there a smartphone was taken into a jury room, and it says juror misconduct gives to her a rebuttable presumption of prejudice. So just the phone being in a room is misconduct. Then we get to argue whether there's prejudice. Again, the timing involved and the sworn allegations made by Mr. Taylor and the attachments establish that there's a reasonable possibility that there's a cell phone in the jury room, and then thus a reasonable possibility that there were not only outgoing messages, but incoming messages that may have been shared with other members of the jury. And the problem with that is that's when we have juror misconduct, when there's information, outside information is used by the jurors in reaching a verdict. And so we think juror interviews of each juror in the case should be granted, and also on a limited basis. The first question to each juror would be, did you bring a cell phone into the deliberations? Did you see anybody else with a cell phone? Did you see anybody else leave the room and go in the bathroom and hear them talking on a cell phone? And if any of those answers are yes, then short follow-up, was any information shared with you from the information that was communicated on the cell phone? We don't get to ask, did they rely on it? We don't get to ask, you know, for their cell phone number. We don't get to, you know, expect their cell phone. We get to find out whether they saw a cell phone, they brought a cell phone into the room, or whether they saw anybody else, and whether that cell phone was used, or the information from the cell phone was used during the deliberations. I think it's limited to that, and that's consistent with the case law. It has to be limited, but then we get to decide if that bears any fruit and there was a cell phone in there, then we get to argue whether there was prejudice.
Yeah, then we can get to those next steps.
Yes.
I know you just came on, so you may have to ask Mr. Taylor the answer to this. Do you know what efforts, if any, have been undertaken to this point to identify
That
hoodie guy? Again, if you need a minute, I know you just came on.
I
so-
do know, but what I know is that they contacted the television station to try to get copies of the texts and emails online. I know the television station was a little bit unresponsive. Beyond that, I don't know what efforts have been made.
All right. Do you know?
That's accurate. No,
All right.
we were shut down pretty decisively by the television station.
All right.
I
Thank
don't have
you.
anything further. That, for those reasons, we believe juror interviews on the first issue, Juror 15 should be interviewed on the limited basis I discussed, and on the second issue, each juror should be interviewed on the limited basis I discussed.
All right. All right. Thank you both very much. I'm going to just give you a ruling from the bench because both sides laid it out, I think, very well in your motions, the objection, the case law that was provided. And I will say, even though I had not received yet or reviewed the transcript of the jury selection, I just happened to be there the whole time and have a very firm remembrance of what happened. With that said, at this point, the only issue that is before me is whether to grant the interviews or not. I don't make findings of prejudice. I don't make findings of credibility. I'm not in any way interpreting the posts that appeared in Defense Exhibit A to the motion to interview jurors. I don't express any opinion or thoughts or make any findings regarding the answers given by Juror 15 during voir dire, the answers provided on the jury questionnaire. No findings. The only issue before me is whether to grant those interviews or not, and then, if so, to decide the process that we're going to follow during those interviews. And having reviewed the law, not only the law that was obviously provided by the parties, but reviewing the rules and the case law that is applicable to interview jurors after a trial, it is extraordinary. There's no doubt that this is an extreme step. But at this point, there is sufficient evidence in front of me to grant the request for the interviews. The issue then becomes the process to follow to make that happen. Again, I think the issues of prejudice and whether anyone would have or would not have exercised a peremptory strike are for another day. So the issues I think we need to discuss are several, and I'm going to lay those out, and then I'm happy to hear briefly, and I say briefly because we were scheduled from 1:30 to 2:30, and there's some folks here that are waiting for their hearings. So I'm prepared to hear briefly on the following issues. Should this be in an open courtroom or in camera? As referenced by Judge Overton in one of the footnotes, which I had, and I appreciate you having that because there's two ways to do it. There's some case law you'll see out there where the court allows the parties to ask questions. And you'll see, of course, in Judge Overton where he approved a process where the court asked questions. My thinking would be if I am going to ask the questions, I'd certainly, you all could tender questions to me and I could decide whether to ask them or not and just see if it's error or not. And then how to bring the jurors that have been released by the court back before the court for interviews. Do they need to be subpoenaed, or is an order to appear sufficient? And an issue that came up today, and I will say that I think the cell phone issue, just so you have the benefit of my thoughts, the cell phone issue was certainly, factually speaking, I think more clear in my mind and towards granting the request for the interview. But as I heard the argument and considered everything today, I think the defense has made, I don't want to say a prima facie showing, but I'll use that word, I'll adopt the word you all used, a prima facie showing that you should be allowed to ask some questions and clarify from Juror 15. I do not at all disagree with the framework suggested by counsel, Mr. Pennell, regarding those questions that I think are relevant and can be asked. And then it'd be up to the defense to argue how that would be prejudicial, and if it is prejudicial, and whatever other issues you need to argue. But what I had not necessarily thought about until it was brought up today is the issue that the jury questionnaires, this is not something we often think about when we're picking juries, are essentially, while not under oath, there is certainly a written, it reads very much similar to the written declaration in lieu of notary in 92, chapter 92, 585? Don't quote me on that. I think it's 585, but it's somewhere around there. The written declaration in lieu of notary, and it does make me think that I should at least offer counsel to Juror 15 and at least give her the option of that. So let's start with, it's your motion, so I'm going to start with you. Defense, and again, when I say briefly, in camera or in the courtroom? And let me just say before we get into too far into this, I see this as a different issue than excluding a witness or a person from a courtroom. I think this is a different matter, so that's why I'm deciding whether in camera or open courtroom. Mr. Taylor.
Now, my instinct and street sense tells me that we will probably get a more candid response if it is in camera rather than the pressure of public.
I agree. All right, so they will be in camera, where, I'll let you know specifically, whether we do it in here and it's electronic, or we do it in a jury room or one of the meeting rooms, I'll decide that. Because also, when we bring in the 6 jurors, because my intention would have all of the 6 at the same time, but I'm going to put them in separate jury rooms to await the questioning, obviously, just in case you were wondering. Court or attorney questions?
Me again?
Yes, sir.
As much as I would like to question them myself, once again, I think perhaps the most candid circumstances would be most conducive to the court questioning, with the proviso that the parties get to submit potential questions to Your Honor, and with the further consideration that based upon what we might hear, that the court would give us an opportunity for a follow-up.
Go ahead.
I would ask the court to do the questions, but I don't believe that there should be any follow-up.
What was the last part?
I don't believe there should be any follow-up
Oh,
questions.
I don't need follow-up by us, I mean follow-up by the
Right.
court.
so if you think about the scenario in trials where jury questions are allowed and the process we go through, that's what I'm envisioning. As I've said before, I have no problem taking good ideas from other areas of law and plagiarizing and using them, and I think that process, so my intention would be, if you all want to send forward some questions, that's absolutely fine, and those will be what I will work from. And as we go, depending on the information we receive, I may then send that juror out. You guys can pose additional questions to me and go that way. So that may take a little bit longer, but I think that'll be the most effective way to get all the information that both sides are trying to get. All right, so it'd be court questions. The next is how to summon them. I'll just say, I think an order to appear is sufficient. However, I wanted to give you the opportunity to make any arguments in case there was a position or some case law that I'm not familiar with that says, once I discharge the juror, my efforts to issue an order to appear is a nullity.
I would suggest a phone call from the court's JA would do it, and I think that would be the least intrusive and the simplest, and in the event that one of the jurors rejects that, then I think we can address subsequent measures to the court. But I would guess a phone call from the JA requesting that they attend the proceeding would be sufficient.
I would defer to the court, Judge.
All right. I appreciate that. You would be shocked the number of people that don't respond. But with that said, I think I'm going to do an order for each juror to appear, each of the 6 jurors to appear on the date and time. So I'm going to have Kelly reach out and coordinate with the both of you to find a day and a time. There's 6 jurors. I would love to say 10 minutes each, will be done exactly an hour, but I don't think that's realistic. So I'll probably ask her to block off 2 hours with you all. And this really, you don't have a dog in this fight. I think this is really more of a concern for the court. Does anybody want to be heard on the issue of Juror 15 and her order to appear having the offer of court-appointed counsel?
So I can only address this from my perspective as criminal defense attorney. If Ms. Walcott were, well, let's use a hypothetical. If somebody similarly situated as Ms. Walcott were to come to my office and I made arrangements to represent them, I would advise them to invoke their Fifth Amendment right to remain silent for 2 bases. One, potential perjury, and we can say, Suzanne can stand up and say, look, we have no intent of charging a former juror. She may feel differently, or her office may feel differently in the event this results in a new trial. And secondly, I would advise my client to invoke the Fifth Amendment, Judge White, based on the fact that as a result of her failure to respond properly to the voir dire questions, that she has exposed herself to direct criminal contempt by the court, and the court may very well have the authority to assess costs of that prior trial. So I think you'd be doing the right thing to advise her.
I'm just going to make the offer. Do you want to be heard?
No.
Okay. All right, so I'm going to advise Juror 15 that she is certainly entitled to hire an attorney, or the court will consider appointing an attorney to represent her if she financially qualifies, and then she can certainly make those arrangements through my office. We can put her in touch with who she needs to fill out that paperwork. All right, so with that said, I guess, keep your phones on or your emails open. We'll be scheduling a 2-hour block. Send proposed questions if you want.
Can I just ask a question about the questions for Juror 15? Are there some parameters that, I mean, what exact questions is the court looking for to accept? mean,
I
what-
don't think it would be appropriate for me to give you that, a preliminary ruling. I'm just saying, submit what questions you want. I'll ask the questions I think are appropriate. There were some suggestions earlier by Mr. Pennell that I think I spoke favorably of, but I'm not making any preliminary rulings. Submit what you want asked.
And I guess my question is, ultimately, can we have discussion if we do have an objection to a question? Or is it the court's discretion?
I think it's ultimately my discretion.
Okay,
I think this falls squarely on my shoulders. I just want to give you all as much input and opportunity to be heard as I possibly can.
okay.
All right, thank you all very much.
Thank you, Judge.
I'll be issuing an order, but it'll be a very short written order.
Okay, yeah, I don't know if the judge wanted, if you wanted ones to at least consider scheduling. We've got a lot of people in this mix, including 2 professional schedules, so.
I'm gonna let you guys handle that with Kelly. I don't have days and times with me right now, but as I've said before, mornings, evenings, Saturdays and Sundays, I will make myself available. You see the laughs, because they know I'll be here on a Saturday or Sunday.
I have no doubt.
All right, thank you all very much.
Thank you, Judge.
And thank you for the very, very detailed, no, seriously, I'm not joking, the motions, the memos of law, the case law, thank you very much. It gave me a lot to review before I came in.